a suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
Yes, indeed. It is that time of the week when David Whiting would sashay into the studio, but he can't because of COVID, but I'm sure he sashayed into a lounge chair in his living room. Is that right, David Whiting? Good morning.
Sitting in the office at home.
Oh,
almost as good as a lounge room, but, not quite.
I thought you might turn the radio up and listen to your little sting there as you sashay in to do this session. Yes, it's a shame that you're not here. Now, no homework, as I understand it, from last week?
No, homework free.
Oh.
Homework free.
Oh.
Had the week off.
You did indeed.
Can't go anywhere, but I had the week off. Yep.
So is there anything that's happened in the legal world that you want to bring to our attention prior to taking calls?
Well, I did wonder, as you are aware, there was effectively a lockdown of the city last Saturday. And I went to have a prowl to find out where the police get the authority to close down the area. And I found it in a government gazette from Wednesday the 15th of September. It's the Control of Weapons Act 1990, which allow, once the area has been gazetted, and you see it sometimes in areas where the police are expecting there might be some trouble, and in this case, it was basically the whole of the CBD, and it ran from Hoddle Street in the east to the Dockland Stadium in the west, and from Victoria Street in the north to Domain Road in the south. So it was huge. And in that area, police and protective officers are empowered to search you. And it's an offence to obstruct or hinder a police officer on duty, and a police officer may also direct a person to leave a designated area if the police officer reasonably believes that you intend to engage in conduct that would constitute a fray or violent disorder. So it's a very interesting piece of legislation, not being used for what I thought it was expected to be used for.
So what I actually had thought that the shutdown on Saturday would have been under some sort of a public health order. No, it's under the Control of Weapons Act 1990 now, and in that period of time they're entitled to stop a person or a vehicle in a public place and search them. It's an offence to refuse to be searched. It's an offence to refuse to provide your ID, and you can be forced to leave the area. Under this reasonably believed to be about to commit an offence, it's...
If the police believes you're reasonably coming into the area to do one of those offences.
Okay.
So I imagine shopping at the market was a bit quieter that day than it might otherwise have been.
Well, absolutely. Well, as you say, it was a huge area. That's
vast.
Yeah,
not just Hoddle Street to Victoria Parade.
Yeah, that's huge.
No. More than the city block.
Let's get to calls, 1300 222 774. Timothy in Coburg, you are first cab off the rank. Good morning.
Good morning. Thank you for taking my call, both of you. This relates to powers of attorney for my parents. As it currently stands, the power of attorney falls to, if Dad's incapacitated, it falls to Mum and vice versa, and then it falls to either myself or my sister. We're wanting to establish enduring powers of attorney that override that, but we wondered what the situation would be. Mum's been assessed to be able to make these decisions, but Dad may not be as a result of a stroke and some epileptic episodes. So how do we obtain power of attorney to manage Dad's affairs in that instance?
Okay, the answer is that it's really a question of at the time he's able to... So the epilepsy is affecting his motor skills or his cognitive skills?
Well, as a result of the stroke, he has aphasia, meaning he can't talk properly, but we don't believe it's affected his, intellect, his intellectual capacity. There is
in the Powers of Attorney Act, there's the ability for someone to sign the power of attorney for him.
Okay.
So there are steps that you need to follow, and it can't be a relative of the person getting the power. So you couldn't, if the power of attorney was to go to your mother and your sister, you couldn't sign it on your dad's behalf.
Right.
But there is a process for powers of attorney being executed for someone. If he doesn't have the mental capacity to grant a power of attorney, then nobody can sign one for him. And what you would need to do is make an application to VCAT for something called an administration order.
Okay, that was my question. If we got to that point where, okay, so through VCAT, that's done through VCAT.
Yes, but my starting point would be if you're satisfied that your dad has the capacity to understand what's doing and to properly instruct somebody, then the power of attorney can be signed on his behalf.
For example, by a lawyer or something like that?
Yes. Yep.
Good on you, Timothy. Laura in South Yarra talking about VCAT. Good morning, Laura.
Good morning. David, in relation to paying VCAT costs for legal representation, I was always of the understanding that if you elect to appoint your own lawyer, each party is up for their own legal costs. Is that the case, or have things changed since?
That is the general proposition. Right? So the general proposition is that each party pay their own costs. Sometimes, in fact, in a supplier or a trader dispute, the person who is successful, who has paid an application fee, would normally get an order that the application fee be paid by the other party. So if you were selling me goods, I had a dispute, I took you to VCAT, I paid an application fee. If I was successful, then VCAT would normally order you as the supplier to reimburse me for my application fee.
So, Laura...
I've been ordered to... Hello?
Yes, I was going to say, Laura, tell us about your situation.
I've been ordered to pay $20,000 for a very trifling matter of feeding some birds. One of the other unit owners took this action.
But took action against you for feeding birds. Laura, can you just clarify? They took action against you for feeding birds?
Yes, on the property.
Right.
It's an owner's
and was
corporation.
So it's a matter under the owners corporation list, and there's a dispute between owners in an owners corporation, and you've been stuck with a cost. Sorry, is the $20,000 all costs, or is some of it damages?
No damages whatsoever, because the pigeons and birds have caused no damage at all, as much as they try to prove otherwise. But
so what was the makeup of the $20,000? Yes?
Yeah, $10,000 of that is pretty much the other party's legal costs.
Yes.
And another $10,000 is for this absurd microbiologist that was appointed to come here and take samples. He was here for about half an hour, and I was astounded.
So you've got an order for professional costs for the advocate who represented either you or the owners corporation, and also for witness expenses and for the experts report.
Yeah, so-called experts. It was just a farce, really. I mean, what is whatever they found in my unit meant to extrapolate or have any adverse effects on the external environment? It's just ludicrous, really.
Laura, don't know.
But Laura has to pay, David, is that?
If there's an order made by VCAT against Laura, yes, she would need to pay, and it can be enforced as a judgment of the Magistrates Court.
Laura, good luck with you. Just on that, the law that you were referring to at the beginning, David, about how...
Control of Weapons Act.
Yeah, and Puri in St Kilda says, the law's ridiculous. My son and partner were walking early Saturday morning through a park in Collingwood where they live. They were stopped by a lone policeman, asked for ID, told to leave the park and walk through the street. And none of what you just said was actually explained to them, and they felt threatened, and it was totally unnecessary as a use of power. There you go. I wonder if other people found themselves stopped on Saturday.
Quite a few. If you were walking in a park west of Hoddle Street on Saturday morning, that could happen to you.
Yeah, or south of Domain Road. I mean, such a big...
No, north of Domain Road.
Oh, north of Domain Road.
Yes,
of course, north of Domain Road. Mary in Mildura. Good morning, Mary.
Good morning, David and Ali. I bought a new phone last week and it didn't have a charger with it. So I went to another local tech support shop and bought a charger. I since came home and discovered my old charger actually works with the new phone. So I took the charger back to the IT shop, got a receipt, the charger's still in the box, never used. They won't take it back because their cancellation policy does not cover do not want items.
Yes, I can understand that, Mary. The assumption is that a contract is a contract. They agreed to sell, you agreed to buy. It happened. Now, lots of organisations have refund policies and return policies for change of mind, but they're not obliged to.
Should I have asked for the return policy, David? Is that my responsibility when I buy things?
Well, no, I think the assumption from everybody's point of view is that it's a firm sale. Right? What you're doing is you're coming along and saying, I want a cooling off period on every transaction that I enter into.
So
that's going to be, that doesn't exist as a concept of law. I know the big stores in town and smaller ones have return policies, but more often than not, the organisation is not obliged to do that.
Mary, I'm sorry about that, but all I can think of is, gosh, you went into a shop because, of course, you're in Mildura, so you can go into a shop. Not something we can do here. Lynn in Shepparton. Hi, Lynn.
Good morning, Ellie and David. Hoping that you can help me with a query. We own a unit on a strata title and there's one other unit on the block. We don't have a body corporate. We share the premium for a strata insurance with the other owner. And
so you do have a body corporate, Lynn. It just doesn't do anything.
Okay. Well,
all right. It came into existence by operation of law when the plan of subdivision was registered.
Yep. All right. So there's quite a bit of common area, and a lot of the common area runs along our unit. So it's a sort of grassed area, and there's a garden. And what we're wondering how we go about leasing a little wedge of that common area so that we can use that for our, to extend
as a private garden. Is this to use the space or to extend the building?
To use the space. So
then you could do that with a lease from the owners' corporation. So if you and your co-owner, and as I said, the owners' corporation exists at law, the owners' corporation and your neighbour and you could lease you the space.
Yep.
You see it quite often in where people have enclosed courtyards on apartment blocks.
Yep.
So it is possible to do, it's not hard to do, but you would require the consent of your co-owner.
And where do we find this information? Do we find it on a website somewhere or about the owners corporation? Where do I look for that?
I would have a look at do you have a copy of your plan of subdivision, Lynn?
Yes. Yep.
Well, it will show you could have a look at thelawhandbook.net.au, which is a community service legal guide from Fitzroy Legal Service. There's a section in that in Owners Corporation.
Okay.
You might also talk to the Victorian Law Reform Commission. At one stage they wrote a guide on owners corporations, which is slightly out of date but still valid. And then there's the thing called the Owners Corporation Act that you could look at. But if you want to do something that would be for the benefit of not just you and your partner, but somebody you might choose to sell your unit to, I would probably invest some money and see a lawyer.
Lynn, good luck with that. Paul in Macedon. Good morning, Paul.
Yeah, hi, Ali. Hi, David. I'm the owner of a unit in a residential high-rise, and we've got one of the tenants operating a motorcycle repair business in the common car park area. We want to put a stop to it, but just curious what our options might be.
It's an interesting question.
Well, it would be an action by the owners' corporation as the manager of the common area.
Yeah, we've sort of issued letters and those kinds of things. Just wondering if there's anything to do with the council, operating an unauthorised business, that kind of thing.
Yes, there will be. He'll be running the person with the repair business will be likely to be in breach of the planning scheme.
Okay.
But remember, you're going to be joining a queue. There will be, if you think it constitutes a nuisance, then you have the right to go to council to say that someone is carrying on a nuisance in your area.
Mm-hmm. Okay.
And they're more likely to investigate, council's more likely to investigate a nuisance than a breach of a planning scheme.
That sounds like a good piece of advice. Now, Malcolm in Ballarat. Oh, you've got an interesting question too, and one that I reckon in different guise probably affects lots of people. Tell us your story, Malcolm.
Yeah, good morning, Ali and David, and thank you for taking my call. Yes, I'm with an amateur theatre company. It's existed for about 70 years, and we have a lot of props, costumes, and of course the backdrops and everything else stored. We haven't been using them for the last 18 months. They're stored in what was an old cool store on a farm. We rented it. It's a normal legal rental transaction. Now, the farm has been sold, and the owners have given us until about October 10 at the latest to get out. We are having difficulties, however, because we can't get there. I live in Ballarat. A lot of the other people associated with the company live in Greater Melbourne. This store is in Greater Melbourne by definition, and we can't get there. So,
so David, what do they do if they can't physically get there to move things?
Well, there are certainly regulations that relate to that allow the real estate industry to keep operating, Malcolm. You've given me the information that I wanted. They're stored in Greater Melbourne. I will give you your answer next week.
You know, David, I reckon that they'll, the answer will probably come back that you have to hire someone to, maybe to do it with you, because I know we moved house during lockdown and we had, a lot of rubbish and stuff that we would normally have put in the boot of the car and taken to a waste transfer station. And of course, they're all closed. And when I rang the council, they basically said, no, can't help you. You got to pay to have it removed.
Yeah. I think it's likely. I think what Malcolm would really like to be able to do is go and pack it up properly for shipping purposes rather than... And then, of course, they've got to find somewhere to take it.
And it will cost you a fortune if you've got to pay someone else to pack it up for you. Here's, I imagine, a fairly simple question. Claire in Sunshine, good morning.
Good morning to you both. Thanks for the program. My mother made a will in New South Wales about 7 or 8 years ago. It has her address in New South Wales on it. She's since moved to Victoria and lives with me. I'm just concerned as to whether that will is valid.
If it was valid when it was made, Claire, it's valid today.
Oh, fantastic.
So state lines don't make a difference, David?
No, you test the validity of the will. You test the validity of the will where and when it was signed. So the fact that she shifted... I mean, you think about it, Claire, we have lots of people who live from a house into an aged care facility and then die. No, the fact that it's interstate would mean no more than if it was in the next suburb.
Very good, Claire. I thought that would be quite a simple question. Sandy in the city. Hi, Sandy.
Hi, how you going?
Good.
David, I'm just ringing about an issue relating to the noise in the wastewater pipe that runs through my apartment building, which only appears to have manifested itself in my apartment, nobody else's. And I moved in here earlier this year, and when it became apparent what the noise was and where it was coming from, the building manager, to his credit, did try to get it rectified with a plumber. To no avail. They couldn't figure out what was causing it. So in the end, they put a heap of insulation around the pipe, which has dampened the noise. It's an intermittent noise, but it happens quite regularly throughout the day. It's a
knocking sound, yep.
Yeah, it's not water hammering. It actually sounds like a brick rolling through the pipe and now that they've put the insulation in there, it's dampened it a bit. But I just wondered whether I had any rights in going further in having it looked at and getting it resolved 100%. Like having
Sandy,
the noise go away.
did you buy it from the unit from the building developer, or did you buy it from a private individual?
Yeah, I bought it from a private individual, and I discovered this building is about 20 years old. And when I realised what it was, I got in touch with the previous owner. She'd lived here for 10 years, and she knew about it, and she didn't disclose it. But she said, oh, yeah, that happened the whole time I was there. I just thought it was, a plumbing issue. So,
Sandy, you have no claim against your vendor.
No, that's fine.
Because the consumer law provisions don't apply. The answer was there was no there, and your building guarantee will have long gone for a building that's 20 years old. The answer would be no. There is no one you can get compensation from.
Nope, you're on your own, Sandy. Sorry about that. Adam in Bayside. Hi, Adam.
Yes, hi. Look, I live in an apartment building that's heritage listed. Do I need to get a planning or building permit to remove internal walls?
You would not normally need a building permit to remove a non-structural wall.
Right.
If you're going to modify a structural wall, then a building permit is likely. So one of the questions will be, what support does this wall provide for things elsewhere in the apartment block? My next issue will be is that there are a whole series of different heritage overlays, some of which have no meaningful controls, some of which go to painting, some of which go to structural. Now, I once looked at moving into an office building in the city that was was subject to Heritage Victoria, and the number of hoops that needed to be gone through were extraordinary. So you need to look and see what the actual heritage controls are affecting your building, and before you start removing internal walls, make sure they're non-structural.
And David, even if it's not a heritage building, often the body corporate will have rules, won't it, about moving things, even if they're not structural walls. If you're doing, substantial renovation, even ripping up the carpet and putting down floorboards, you need permission. It can be written into the body corporate.
It's quite interesting. There are quite a few owners corporation rules out there which claim to have jurisdiction in circumstances where they don't. The general proposition is that what's inside your unit is yours. Everything below the ceiling and above the concrete that your floor is placed on, and everything inside the walls is yours. So as a general proposition, if you were to refit your apartment, you're unlikely to require approval from the owners corporation. But remember, you're not supposed to do anything in your unit which is going to make life worse for anybody else. So, the trend these days seems to be for floorboards. Floorboards can make a hell of a racket for the unit downstairs.
Yes, you need appropriate acoustic padding.
Yes, okay, perfect.
David, thank you. You will be back with us again next week, won't you?
Yep, talk then. Thanks.
Excellent. David Whiting there, Melbourne solicitor, answering all your legal calls, and he'll be back, of course, next Tuesday doing exactly the same thing.